So today's topic is about case analysis and, to a lesser extent, evidence gathering. When I was given this vast and perhaps ill-defined topic to deal with, and so I had 15 minutes to deal with it, the first thought really occurred to me is this, and it's what I want to focus on today, because it's probably the point of most relevance to those just starting out, and the common mistakes that we've all made as junior lawyers, and as counsel we see very junior lawyers making. And the fundamental problem that goes wrong with case analysis is that one tends to focus on the details of the event that goes wrong when a client comes in and presents us with problems, if you like, the what of the issue. Disputes don't materialize out of nowhere generally, unless what you're concerned with is a straightforward debt claim. There is a narrative, often a compelling one, and there's a temptation to focus on the ins and outs of the event that has gone wrong. And there's a number of other matters around it which are far more fundamental and which, if not dealt with correctly at the outset, can prove to be a significant cause of error and wasted cost. And the simple point and the good habits, I suppose, I'd wish to inculcate in those listening today is this, that before asking what and focusing on the detail of what went wrong, there are really 5 topics that you need to focus on. What I'll call the who and why, the parties that can properly sue and be sued, and the basic elements of the course of action without worrying about the details. The when, and this is really a point about limitation. The where are you going to pursue the individual? Where can they be pursued, and where should they be pursued? The how much. What is the client going to get out of this litigation, be it in terms of monetary recompense or some form of non-monetary remedy, and the how. In what forum can a party properly be pursued? And while this process of case analysis, it can be an iterative one, the other good habit I wish to inculcate is this, and that is that one is always working backwards from a desired outcome. Clients ultimately want a particular sum of money, they want to apply commercial pressure on someone, they want an injunction, and so on and so forth. The temptation often is to work forward logically from start to finish, but as I'll show, actually working backwards from what is feasible often is critical at an early stage, because it prevents parties from embarking upon claims which may, in the course of time, hit the rocks. So in terms of the who and why, obviously with most contract cases, it is obvious who the parties to them are, but it's always critical to be alive to potential issues around the margins. Is the identity of the party, if you have a written contract, is the identity of the party sufficiently defined? In the case of an oral contract, you may have a dispute as to whether or not the relevant party was a corporate entity or the human individual who conducted the relevant negotiations. And it's always critical to pin down the evidence on that, the emails that were exchanged, and so on and so forth. Equally, there may be an issue as to agency. How is the contract signed? By whom is it signed? Is the agent potentially liable? Is there an undisclosed principal sitting? Can a particular party sue as an undisclosed principal? It's always important to have that as a reflex there. Equally, in the case of assigned contracts, it might be thought that this won't throw up too many difficulties. You're sharing a notice of assignment and you decide that's that. This particular party who wishes you to bring a claim on their behalf can pursue the matter. But indeed, as has occurred in a number of cases, including the Promontoria case in the course of appeal earlier this year, actually, you may need to prove the assignment agreement. That may need to be pinned down. Again, that is something not to be overlooked and is a reflex that certainly it's useful to have. Other matters sometimes overlooked are potential claims under Contracts Rights of Third Parties Act 1999. It's true that 99% of contracts we see exclude that act's operation in its entirety, but your contract, the state of affairs that you are dealing with may happen to be the one contract that doesn't contain such an exclusion. It's always worthwhile double checking that. And of course, obviously, when you're dealing with a corporate debtor, there will be an issue as to whether or not PGs exist, and that's something that also routinely ought to be checked. In terms of evidence gathering in a contract case, the first question is always, what is the contract? Is it oral or written, or is it a combination of both? And while this may seem an extremely glaringly obvious thing to say, it is critical whenever you have a client who alleges that there was an oral contract, that at the earliest stage of the engagement, you are asking them who said what to whom, where, and when, and using what words. Now, as obvious as it might seem, if I had £1 for every case where there has been a pleading and it is merely said it was agreed X, and no one's actually interrogated whether or not X or Y was agreed or who did it, and the matter's got as far as the CCMC, I might not be a millionaire, but it certainly wouldn't do my bank balance any harm. This is a matter that at the earliest stage of any agreement, of any engagement, really must be drilled down into. And in terms of assessing the credibility of any case or any potential difficulties, you've of course got to look at the surrounding correspondence in and around the time that the alleged oral contract was entered into, because even if the actual exchange that gives rise to it was on the telephone, clearly if there were emails passed about a potential project or something of that nature, then those will inform an assessment of the plausibility of whether or not something was or was not said orally. But another point which is often overlooked is that in the case of an oral contract, evidence of what the parties did after the date of the alleged oral contract is good evidence of what was actually agreed beforehand, because if parties have taken particular steps, it stands to reason that they're referable to an agreement. That is overlooked. The authority for that proposition, by the way, is the case of National Power and Carmichael there. Again, at an early stage of the engagement, if the client says, well, this was the oral agreement, well, you need to drill down with them into what actually happened and then proceed to see whether or not the records, whether by way of emails about the particular topic and so on, or invoices or timesheets or whatever it happens to be are consistent with the alleged oral agreement. In terms of evidence gathering at an early stage in a written contract case, very often, if, say, you have a property sale or a lease or a very formal contract, it may simply be a case of securing the executed version of the document, because the content of the agreement will depend on the four corners of that document. But of course, there are issues at the margins, and there are really 3 points I think need to be focused upon. The first is when you have a battle of the forms. If you have some sort of sale of goods, plant hire, that sort of case, typically there will be a battle of the forms, with one party sending in their terms and conditions, another party sending another document back which purports to include theirs. And again, this is an obvious point, but it's critical that where that sort of issue looks like it might arise, you will need to get the client's Outlook PSTs, their WhatsApps, text messages, any other emails, and order those chronologically and just work through them to see what was and wasn't agreed. Another common issue in relation to written contracts, and this, for whatever reason, seems to crop up quite a lot in the communications and IT services industries, is what the relevant terms and conditions are. It certainly seems that there are some commercial actors that say, well, this incorporates our standard terms and conditions, but indeed when you dig down into the website where they claim to have the terms and conditions, there are 7 or 8 different documents which could potentially qualify as terms and conditions, each with mutually inconsistent provisions and that sort of thing. I mean, in those circumstances, it's simply not going to be possible for the party claiming that the terms are incorporated to assert that, because one has to ask, well, which is it? And that's an issue that came up in the Blue Sky case, which was before His Honour Judge Stephen Davis last year. Again, it's a straightforward point, but the minute you see T&Cs available on the website, well, dig down into the website. If you can't find them, one practical hint is that there's a website called the Wayback Machine, which logs historic versions of websites, and most commercial providers will have had commercial services providers will have had their site indexed about once or twice a month for the past 10 years by that site. I had a case recently where I went on to the Wayback Machine. We found the old terms and conditions. We were able to show that there were 10 sets of terms and conditions. None of them could apply. And I got the contract out, the client out of a very onerous telecommunications contract. So always be alive to that, and always be alive to where that can be found. And of course, in a more conventional contract, it may just be, well, T&Cs available on request, in which case that is ultimately going to be a matter on which you press the other side. Although in relation to that point as well, if you have an assertion that terms and conditions are a particular set of terms and conditions are the relevant ones, it's always useful to insist on being provided with a native copy, because that will come with the metadata, and you can check whether or not these are terms and conditions which were effective and live at the material time. So that's always something to dig down into. And then the third point, in terms of what is the contract, an early stage evidence gathering, relates to documents other than terms and conditions, which are said to be incorporated into the contract. This seems to be a particular problem in relation to IT and construction contracts. We have a large volume of often tender documents which form part of the contract but are in substance programming specifications or building specifications, drawings, schedules, that sort of thing. Very often what happens with the negotiation of this type of contract is that there are discussions going on between the technical people in parallel to the discussions between the lawyers over the niceties of the final contract that follows the tender for the particular IT or construction project. And at about an hour to midnight before the final contract is signed, documents are uploaded to a website or an electronic medium is created, a CD or a USB key or something containing the relevant documents. They're not actually printed out in the contract, and the contents of those documents are incorporated by reference to the hosting site where the files were held, or the CD that was given to Mr. X on date, whatever it happens to be. And this has actually been proven to be an issue I've encountered 3 or 4 times, both in very substantial disputes, one over £1 million, and small disputes under 25,000. What was the website? What was the storage medium? Who was what was the set of documents handed to Mr. X in the tender department of the council on date Y? So that's always something very important to dig down into, because that can very much affect the scope of the relevant party's obligations. In terms of non-contractual obligations, there's probably relatively little I can usefully say in half an hour's talk, save to always be aware of just the basic outline in your mind of potential other courses of action that might arise where you can't assert a contract, and bearing in mind some of the obvious difficulties you may face. In the case of a tort claim, pure economic loss, the inability to sue builders down the chain of contract, where there's not been damage to physical property other than the thing that's built. Is there a statutory cause of action, for example, under the Defective Premises Act? Could you, for example, sue under the Phoenixing provisions in the Insolvency Act, something like that? Always useful to be aware of those things. Equitable breach of confidence claims, even if there's not a non-disclosure agreement. Joint tortfeasorship, inducing breach of contract, the economic torts. I don't think really these issues don't come up often enough for every junior lawyer to have mastered the detail of these topics, but whenever, in order to be able to analyse anything other than the most simple case competently, it's important just to have a basic map of potential of the cause of action, in the sense of, if to use Donald Rumsfeld phrase, even if you don't know the ins and outs of every potential non-contractual cause of action, you can't allow them to be unknowns to you. In terms of who may sue or may be sued, it's also important to have in mind any issues relevant to their particular identity. Are they a consumer or a trader? Are there special regimes that might apply that don't obviously jump off the page? Is there in a, say, dispute over a loan, the kind of case you might commonly come across, is there a potential for the Financial Services and Markets Act to apply and FCA regulation to apply, that sort of thing? Again, these are things we can't cover in the scope within the scope of this talk, but it's important that you always have the reflex to go and look. The other thing that's critical and often gets overlooked at an early stage is whether there's any point suing the particular defendant. One of the first things I do with a file is to check on Companies House. Look at if you've got a corporate defendant, that is, look at the accounts, see whether the company's good for the money, who are the directors. The potential reason for that is if you have a claim against a company which the company itself might not be able to satisfy, but it's a substantial sum of money and it'd be worth chasing the directors, it may be worthwhile chasing the company if there's a potential that the directors have done something to misappropriate funds from the company and might be required to put them back. So that's always something to have on your horizon. And in relation to individuals, if it's always worth asking the client in the first instance whether or not what their impression is of the potential defendant in terms of whether they think they hold property, and if there's any doubt about that, it's worthwhile paying for searches to be conducted to check whether they own property, whether they have a history of defaults, because ultimately there's no point spending £60,000 to chase £30,000 in respect to someone who can't pay either. So that's always something important to check at an early stage. The next point is when. This is a critical reflex. And it's probably the first thing that counsel always check, because we get papers in, we get time to deal with them. Clients leave things late, and you face limitation issues. Limitation, of course, again, is a vast topic in its own right. And again, it's just important to have a map of the basics. Contract 6 years from the date of breach. Tort 6 years from the occurrence of damage, and in the case of a transaction being entered into, whether that's misrep or solicitor's negligence, the date of damage is the date on which a party became irrevocably committed to it. There's the potential in relation to claims for negligence only, but not other cause of action, of the 3-year extension under Section 14A of the Limitation Act. And of course, there's the suspension of time running under Section 32, where there is fraud or concealment, deliberate concealment by the party in breach, and time only runs from the date on which that could have been discovered. In terms of evidence gathering at an early stage, if you've got a case that looks like it's out of time, then obviously the first thing you've got to check is whether or not there's a basis for the application of Section 14A or potentially Section 32 if you've got a case involving some form of dishonesty. And really the critical thing to do here is to search the client's emails, check when they first discovered relevant facts about the issue, because that's going to inform an assessment of when it would have been reasonable, when reasonably the client had knowledge about the damage needed to commence litigation, and it would also inform the question for a Section 32 case as to when, although that's an objective test, it does still inform the question when the fraud or concealment could reasonably have been discovered. That's the first task to undertake. Again, you should get the Outlook pack, PSTs, find some keywords, identify the correspondence with the relevant people at the counterparty and run through it, because ultimately you can't afford for the case to fail on that threshold issue, particularly as, there's a possibility that limitation might be dealt on one of these grounds, might be dealt with as a preliminary issue. Chances are, because there'll be disputed facts, it'll rumble onto a trial, and it'll be extremely costly if it turns out in due course that the damage was discovered earlier, or there was knowledge about it, and the claim fails. In terms of where, and again, this goes back to the point I made about considering the desired outcome first. This may not be an issue when you're issuing bog standard debt claims in the county court against people who live in Salford and Trafford, but cross-border cases are by no means as unusual as you'd think, even on the Northern Circuit. The ultimate question is, where you've got any sort of international element to a case, is where does the defendant have assets? It's no good suing somebody. It may be no good suing somebody whose only asset is a house in Spain or Colombia. Suing them here if, for example, there'll be any difficulties in terms of enforcing a judgment of an English court obtained at great expense in Colombia or Spain or wherever it happens to be. And there will be inevitably be the costs associated with that enforcement exercise. So in any case where there's a foreign element, you have to ask, where does the defendant have assets? What's the governing law involved? May not necessarily be English law at all, and ultimately that's a matter to be decided by reference to the Rome regulation. Who will take jurisdiction over the matter? What's the most appropriate forum for the dispute? And of course, will the court, when you get to the place where those assets stand, will the court enforce your judgment? And that is again a matter on which it's less an evidence gathering exercise, but if there's any question about whether you're going to be able to enforce, then you'll have to involve foreign lawyers. Again, this is something to pick up at an early stage, because there is no point spending £80,000 to chase 30 only to find that it'll cost you 40 and you might not be able to enforce wherever the assets happen to be. And of course, the first bullet on service, again, this is only a huge significant concern in limitation cases, but unless you've got the ability to serve on solicitors under CPR 6, or it's a company which can always be served its registered address, you need to know where your debtor is. This brings me on to the how much. And again, my experience is too many cases look like they may be good on liability but fail on quantum. And it's because the root cause of that tends to be because the client just hasn't been pressed at the outset as to what they've said they've lost, how they get to the figures, and what they've got to show that those costs have been incurred. First rule of thumb is you must lock down whatever records they have on day one. And of course, it sounds obvious, but in a contract case, ultimately the issues are breach, causation, and quantum. And my view is, if it's very often, it makes sense to work in terms of the relative importance you give. In terms of sequencing, it often makes sense to work backwards. The same point applies to monetary remedies, because if a client wants, an interim injunction, well, the question is going to be: is not going to be one of the merits. Is there where does the balance of the remediable prejudice lie? And again, you're going to have evidence gathering focused on that, and that will be an issue as to the implications of the proposed order on each of the respective parties. Even in a simple neighbour dispute, there may be a question as to whether or not restoring a right of way will require a fence to be ripped down, and whether who's prejudiced more by that. These are all things that need to be fleshed out at an early stage. Causation, again, just to give one example, as I've done here in a case, we've got a repudiation matter. Well, we've got to ask, that one party complains that the contract's being repudiated, wrongly terminated. Well, would they have been able to terminate? All sorts of questions arise Would they have been able to terminate legitimately anyway? That has to be investigated. And indeed, if there are facts which have appeared since the repudiation, those can be factored into the assessment of what the hypothetical assessment of what would have happened but for the breach. Again, these are things not thought about but ought to be investigated. Mitigation, you should always, at least in any sort of damages claim, you should always check what the claimant in fact has done since the breach, what could have been done to mitigate any obstacles, because that's inevitably a matter a defendant's always going to raise. And in terms of evidence gathering, I mean, the number of potential different categories of case are legion, but just to give a few examples, in a defective goods case, you should be asking what's happened to the goods, what the defects are, the client should be asked, have they been retained, how many of the items have been retained. And just to give an example from a case I had recently, a client alleged that a batch of 152 items, or several batches, each of which had 152 items in, were defective. They only retained one example of each of the batches, or one or two examples of each of the batches, and then retained the wrong, and then the item that they'd retained on some of the other batches was not the correct item, such that when the experts came along, the evidence that they came to give, even though it was clear that some defective goods had been supplied, when the experts came along, that could usually have been said. Again, that's something to check. And in connection with that, what photographs do you have, etc. If there's a loss of profit claim, say on a resale, well, what documents actually exist as to the resale value? If there's some particular purpose that's been affected, does it raise a happy and Baxendale point? These are the sorts of things you need to think about. In a claim for lost profits, and there are various different ways that such a claim might arise, whether in an unfair prejudice case where the value of the company's future business will affect the value of the buyback for the shares, or M&A disputes where there's been a breach of warranty or a rescission of the agreement. I mean, that's always going to be, it's right to say that in this sort of dispute, it's always ultimately going to be a matter for experts what the lost profits are. But in terms of what you can usefully do at an early stage, it's important that there be something of a sanity check. If they exist, does the client have its own contemporaneous forecasts of how the business was going to fare, or what its expectations were, and what materials available to show, for example, how competitors would have fared, the market, the addressable market, that sort of thing. Because when the client presents you with those sorts of figures, well, ultimately an expert will be sitting down and producing their EBITDA calculation with the magical application of the multiplier. These are matters that you need to stress test, because a claim that might be said to be worth 3 million might only be worth 50 grand. And again, the same sorts of issues arise, say, in a construction case. Well, the client may well say, well, we were delayed because the employer didn't give us access to site on dates X, Y, and Z. Well, what are the site reports? What do they show? They've got the programs, timesheets, evidence of rates, hire invoices. Well, of course, there'll always be pushback from clients when you ask for this stuff at an early stage, because there's a cost associated, or at least potentially associated with it in terms of review. Again, it's better to have those records early on, to avoid problems further down the line. And the last point is the how. I suppose this is connected with the where, in the sense of course, if a foreign court is the dispute resolution forum. And that goes back to the where point. But there are two issues that arise. One is whether or not you're forced to use a particular form of dispute resolution. And the second is whether or not there are usable alternatives which are not mandatory but might deliver a better result. And again, you don't need to know all the ins and outs of these things, but it is useful to have a knowledge of the lie of the land, as it were. Obviously, if you have a contract that provides for arbitration or expert determination in relation to the particular matter, then you're bound to go down that route. Because the only point of flag now is if there is a dispute resolution procedure associated with that in terms of managerial escalation and that's or mandatory mediation, that sort of thing, that must be complied with to the letter. Another point to be aware of is that there are certain kinds of disputes that are reserved to particular tribunals. For example, the Employment Rights Act 1996 reserves multiple different classes of employer-employee dispute to the employment tribunal, and it's not possible to outflank those limitations by dressing up claims which fall within the employment tribunal's purview as claims under a contract. The case of Edwards and Chesterfield is a famous one where an employee tried to claim more for unfair dismissal than he would have been able to claim in the employment tribunal by dressing it up as a breach of the implied trust and breach of the implied term of trust and confidence. The House of Lords said, no, you can't do that. Parliament has said unfair dismissal is purely for the employment tribunal. Again, that's just one of those things to be aware of. Equally, there are certain types of property-related disputes that are reserved to the first-tier tribunal, service charge disputes, disputes under the Mobile Homes Act 1983, all sorts. Again, it's just important to be aware that exists and that your dispute might fall within it. And then in terms of non-mandatory alternative routes to resolution, bearing in mind the client's objectives, there may be an ombudsman that's empowered to make a decision, particularly the financial ombudsman service in smaller scale pensions cases. Well, of course, the disadvantage for solicitors is that their costs of those, the costs of making a complaint to FOS aren't recoverable. That can be a relatively speedy way to redress compared with the courts. Again, that's something you simply need to be aware of. If you have a construction matter, you may be able to go to adjudication. Well, you typically will be able to go to adjudication under the 1996 Act unless it's a residential house building case. And that's something absolutely to be aware of, not least because if you're acting for a contractor, there may be so-called smash and grab claims available to them, which, for those who don't know anything about this, involve no more than saying that payment was claimed and the relevant procedure for withholding wasn't complied with. That's something to be aware of. And equally, if you have a dispute as to defects, even as between contractor and employer, matters typically do go to adjudication. They're resolved within 28 days, and it's seldom that parties actually litigate. Again, something you absolutely have to be aware of. And then the final I've raised here is the land registry, and this often is a first port of call, although parties don't always think about it, where there are disputes over the sale of property. If there's been a misrepresentation or something, as a first opening gambit, you can object to the transfer on the basis of the misrepresentation. The fact of the objection will appear on the land registry unless it's land register unless it's removed, and that can put considerable pressure on a party to settle. So that's something always to be borne in mind. But yes, I suppose in terms of the major takeaway from today, it's don't focus on the detail of the what, and work backwards from, whenever analysing anything, work backwards from your remedy. Thanks very much, everyone, for attending.